I am Judy Waxman. I'm here with Linda Wharton, who is in New Jersey. And we are going to do our VFA Pioneer History. We're doing it over Zoom because it's during the pandemic. And let's start at the top. Linda, why don't you give me your whole name and when and where you were born?
Yes, my name is Linda J. Wharton, and I was born in Camden, New Jersey.
What was your life like before the women's movement?
Well, um, I grew up in a very working class family. I lived in southern New Jersey. Um, my parents met when they were working at one of the major employers in Camden in the 1950s, RCA, which is probably the major employer at the time in Camden. They were both working there. Actually, my grandmother, my mother's father, was also working there, and she introduced my parents. They then moved out to Cherry Hill, which is a suburban town in New Jersey, just out, still in Camden County. My parents, it was a very working class family. My mother, most of the time, worked outside the home. She either was holding down a part-time job or a full-time job in order to supplement my father's income. I think that had a very strong influence on me because as a young child, I observed my mother working 24/7. My father, though he worked hard, when he came home, the dinner was still prepared for him, and he then relaxed, and my mother just kept going. And I remember as a child just observing all of this and just feeling the unfairness of it. Though my mother took it in stride. It wasn't because she complained. So I would say that was sort of my early sort of instincts about feminism, that there was something off in the world, that women played one role and men played another, and my perception was it was terribly unfair with regard to women and their role.
Uh-huh.
So the feminist movement, I graduated from high school in 1973 and college in 1977. So I was a little bit young to be involved in sort of the heyday of the early 70s part of the movement. But I was very well aware of it. In high school, I remember reading Germaine Greer's book, The Female Eunuch. And I love that book. It just resonated with me. More so, I think I read Friedan's The Feminine Mystique as well. But for whatever reason, the Greer book just really spoke to me. And in fact, I remember very clearly. I went to Bryn Mawr College, and I did an in-person interview. And the interviewer, Betty Vermey, who was this amazing woman, asked me what book had most influenced me, and I said The Female Eunuch. And I remember she sat up in her chair, very impressed that this young woman from a public high school in southern New Jersey, said The Female Eunuch. And then we proceeded to have a long conversation about it. And more than anything, I wanted to get into Bryn Mawr. And in part, that was about the fact that it was a women's college. It had this amazing history in terms of connection with the suffrage movement and the movement to broaden women's educational opportunities. So I was very, very thrilled to go there. I would say that's when when I got to Bryn Mawr in 1973, the fall of 1973, that's when I became more aware of the women's movement. Just from classes that I took, from interactions with my peers, just from general reading that I did. I don't recall at Bryn Mawr there being a lot of organized feminist organizations on campus. And it's interesting as I reflect back now. And I think that may just be because there was a sense that we're at Bryn Mawr, and of course we're all on board.
Uh-huh.
And we don't really see a need to be involved in these groups. I don't know, but it's interesting. Or else I just, Judy, miss them. But in terms of college, I have some memories of a few things that really impacted me. First, I took a course, and it was about one major focus of the course was women's representation in the media. And I did a paper in which caused me to do a bunch of archival research. I went to the Philadelphia Library and I looked at old newspapers, and I wrote a very long research paper about the depiction of women and I think I in particular focused on women in sports, because I've always been interested in the topic of women in sports, because I had played sports in high school, had been very involved, less so at Bryn Mawr. I think I played field hockey one year, but otherwise was not involved. And just seeing these images of women and the way women were spoken about as delicate flowers and reproductive vessels, really continued to just impact me and move me in the direction that I was headed.
Mm-hmm.
Second thing that I remember is that I had an opportunity the summer between my junior year of college and my senior year of college to go for a week. And it may have been through the same professor who was very connected in the world of journalism, to go for a week and live in Manhattan with a Bryn Mawr alum who had strong connections to Ms. Magazine. I did this for a week. It was thrilling for me. She lived on Central Park West. It wasn't really an apartment. It was like going into a house inside this building. And it was me and another Bryn Mawr student. Every day we would go to either the Ms. office and talk with the editors and sit in on meetings, or some other newspaper or magazine in New York. So we went to the New York Times, we went to the New Yorker, and we got to meet all of these amazing people, but especially the women at Ms. And at the time, a number of Bryn Mawr alums were at Ms.
Mm.
Mary Tom was one of them. They were some of the early writers and editors of Ms. Magazine. And of course, I saw Gloria there for the first time. So that was a really influential experience. I decided, of course, I was going to be a journalist. I was going to write about feminist issues. This was my career path. I also became interested in photography at that time, and I began taking photographs. And so that was, again, very influential.
Mm-hmm.
And it really connected me, I think, for the first time with the world of Ms. and the movement that, sort of was happening out there. And I began reading Ms. at that time, and have kept up my subscription ever since. It's still, every once in a while I think, oh, should I still get that? But I do. And then that same summer, I got an opportunity, and I'm not sure how, somehow through Bryn Mawr's Career Services, to work on a publication. And it was called, I found it because I began thinking about it as I thought about this interview, and I'll hold it up. It's called the Illustrated Women's Almanac.
Uh-huh.
Does this look familiar?
It does, yeah.
And it was a whopping $6.95.
Right.
And it's 12 how-to handbooks for women. The health advisor, the psychological advisor, the sex advisor, motherhood, education, and on and on. And there is a section, I believe, on reproductive rights. There's a legal advisor. And in the back is sort of resources. And I was hired to be the person in Philadelphia who would find the listings of women's organizations in Philadelphia. So I spent a chunk of the summer. I mean, there were no computers. You had
Right.
to find these things by looking them up in the telephone directory and you found out more by calling. I went into the city, I met people, and I wrote a number of those entries. Um, Again, I love that experience. It was another entree into this world of women's health issues, of women's legal rights issues in general. And again, it influenced me a lot in terms of thinking about my future career choices. And I think it's actually through the Women's Almanac that I became aware of women's legal rights organizations, because in Philadelphia is the Women's Law Project, which I would have just recently been founded at that time, because I think it was founded, as I recall, in 1974. So this would have been probably the summer of 76. It was the bicentennial summer when this all happened for me. And I was so intrigued with this notion that there were these organizations that were dedicated to advancing women's legal rights, that sort of opened up another career alternative to me. I've been thinking about journalism, but now I began thinking about law. So those were just really key and important experiences at Bryn Mawr that I think were just really, really key to what I did subsequently.
Mm-hmm. So did you go right to law school?
No, I did not, because I remained a bit uncertain. So I took a year off and I worked at a law firm in Philadelphia as a legal assistant, which was actually at the time a fairly common thing to do. I know my Bryn Mawr roommate who went to Yale Law School did the same thing. She worked in Manhattan. And it was just a year to think a little bit more about this choice to live in the city. I had a Bryn Mawr friend who was my roommate. I lived in Society Hill. And also to raise some money for law school, because my parents had really struggled to be able to help with Bryn Mawr. They had never anticipated that I would go to a school that cost so much money. And though I did get a substantial scholarship, there was still a contribution they needed to make. So it was clear to me that if I was going to law school, I was going to pay for it myself.
Mm-hmm.
I wouldn't even think of asking my parents because they had really sacrificed, to help me go to Bryn Mawr, and I'm eternally grateful for that. So I took this year, and it was a helpful year. I learned in working at a big law firm that it was clear to me that was not what I wanted. That was not the kind of law that I wanted to do long term. I was impressed with the quality of the lawyering and the people that I found there. I saw that they were hardworking, they were smart, they were very good lawyers. And some of them I became friends with, and so that's what led me ultimately to make the decision to go to law school.
Uh-huh.
So I went to Rutgers Law School. I was still, even though I had been living in Pennsylvania for that year, I was still a New Jersey resident, and that is the law school that I could go to, and I knew that I could pay for it. So that was critical to me, and in some ways, I think, was that a little short-sighted and not applying elsewhere. But I was so clear that I had to go somewhere where I could pay for the bulk of it and not incur tremendous loans. And I also was pretty clear that if I was going to stay in law school and ultimately pursue a career in law, I wanted it to be in public interest. I wasn't going to work at a big law firm, so I wasn't likely to command a huge salary. So I went to Rutgers, and I was very, ultimately I've been very satisfied with that choice. Rutgers is and was a very good law school. Um, I met at Rutgers Law School Anne Friedman, who was someone you might know. Anne is one of the founders of the Women's Law Project. Went to Yale Law School, and with Tom Emerson and a few others wrote a seminal law journal article in the Yale Law Journal about the underpinnings, the theoretical legal underpinnings of the federal ERA. That's a very famous law journal article. And so then they came to Philadelphia when they graduated from Yale Law School. Anne and Harriet Katz and Barbara Brown, who were her co-authors, came to Philadelphia and founded the Women's Law Project because Pennsylvania had a state equal rights amendment. And they wanted to place the Women's Law Project in a state that had an equal rights amendment so they could litigate under a state equal rights amendment and establish important precedent under that state equal rights amendment. So by the time I got to Rutgers, it was then 1978, Anne had left the Women's Law Project. I think she had been there for 3 or 4 years. The founders left, and it was, new people then were at the Law Project. But I encountered Anne at Rutgers early on in my time at Rutgers, and we just really hit it off. And I took her sex discrimination law class. I took her family law class. She became my mentor, and we have maintained a friendship now over 40 years, 45 years. I just talked to her last week. She still teaches at Rutgers. She's been there this whole time. So that sort of, I think, more than anything, really set me on my path, or clarified that I wanted to work in public interest law, and I'd really love to work at the Women's Law Project. Mm-hmm. And, Anne really supported me in that. And, I did some research for her. I worked with her. It was a very, and she's a very nurturing, good person. So I did very well at Rutgers Law School, and I was very fortunate to get a clerkship with the Third Circuit. I clerked for Judge Slobiter, Dolores Slobiter, who was the first woman on the United States Court of Appeals for the Third Circuit. She had been a Carter appointee, and I clerked for her in her second year on the bench, and it was a tremendous honor to get to be her clerk. I think I was the first, at least Rutgers Camden student ever to clerk at that level. So I was thrilled to be able to do that. And clerking at the circuit court level is a fabulous experience. To be able to, help a judge thinking through these important opinions. It's such an amazing learning experience and such a great privilege. And one of my summers during law school, I guess it was between 2L and 3L years, I had worked at the law firm, the Deckert Law Firm, which is one of the large law firms in Philadelphia. At the time, it was called Deckert, Price and Rhodes. It's now referred to as Deckert. And the reason I did that was that it's tough to get, it's actually very difficult to get a job, at least at the time, and I think this continues to some extent. But probably it was actually harder at the time than it is now, because I think there's more support for summer public interest law jobs now for law students. But at the time, it was actually tough to get a position at a public interest organization, a paying position. So I got this very generous offer one summer to go to Deckert. and I took it, in part, driven by financial needs. I was going to make a very handsome summer salary, and that was very helpful in paying for law school. And I actually had a choice among a lot of the top law schools and law firms in Philadelphia. And I chose Deckard because I saw that they had done a lot of pro bono work, and they were very generous um, in encouraging their associates to do pro bono work. And I really liked that. So after my clerkship, I did go to Deckard again because there were no positions at the Women's Law Project. They had, at the time, Carrie Nicholas was the managing attorney, and Rita Bernstein was a staff attorney, and Kitty Colbert was the other staff attorney. That's it. They didn't have any more positions for attorney, full-time attorney positions. And Philadelphia, has a healthy public interest community. It's not as large as the DC public interest law community, nor is it as large as the New York public interest law community. So I just thought, well, I enjoyed my summer at Deckard. I will go there, and sort of, this is a great way of getting some training in the law. These are very good lawyers. I will have an opportunity to do some pro bono work. I'm sure this firm will support me in that. So I did go to Deckard, and I was only there a short time. I think it was only, a couple of years. And I then left for a while, and I went to Rutgers Law School and was working there. I was doing legal research and writing and some other courses at the law school, not as a full-time faculty member. My oldest child was born at that time, and I wanted the flexibility to, be on a more sort of work on a more part-time basis. But after a couple of years, I went back to Deckard, and they allowed me to come back part-time. I think probably initially they weren't all that receptive to this, but as the years went on, the big firms became more receptive to part-time. So I went back for a couple of years part-time. And during that time, the Law Project was asked by, Deckard was asked by the Women's Law Project, and in particular, Kitty Colbert, who was still a staff attorney at the Women's Law Project, to join them in a case against Operation Rescue. Operation Rescue, I know you know who they are.
Right.
An anti-choice organization led by Randall Terry, led at the time at least by a man named Randall Terry. In the 1980s, particularly I would say mid to late 1980s, they began assembling large numbers of anti-choice people and coming into major cities and protesting at abortion providers in those cities. Philadelphia was one of the cities. They announced in around, I would say 87, 88, that they were coming to Philadelphia. And what they would do is they would announce it on a Friday and then arrive in really large numbers very early, a few hours later, in the wee hours of the morning on a Saturday or some other day, but with very little notice. And I'm talking 300, 400, 500 people would arrive. And it went beyond simple, permissible First Amendment protest. They would block ingress and egress from the abortion providers. They would harass patients and clinic staff coming into the provider. And generally wreak havoc, for most of the time that they were there. So Kitty came to the Deckard firm and asked if we would support the Women's Law Project in obtaining an injunction to stop activity that went beyond permissible First Amendment activity. A partner there at the time, who was a friend, a close friend of mine, had become a close friend, was Mary McLaughlin, who later became a federal district court judge. She's now has senior status, I believe, but she was very supportive. And she immediately called me and said, I think you'd be interested in this. I said, absolutely. And it's the Women's Law Project. So this was wonderful for me. So Mary and I, with Kitty, worked on that case. And we got an injunction in federal court. And at this point, I don't even remember what the causes of action were, but we had a federal claim. And the judge was Clarence Newcomer. We were successful, before him in getting the injunction. It's called Roe versus Operation Rescue. We got the injunction, and then they proceeded to violate it every single Saturday forevermore. So then we had to get the federal marshals to come in and arrest them. And so this went on for weeks, months, where, we had the injunction and they just violated it, and the marshals came every Saturday and arrested them. Eventually it ended, but we accumulated enormous amounts of attorney's fees for the Women's Law Project, which we were never ever able to obtain. But we had the injunction, and to that extent, it was a success. And I think we did prevent some of the more egregious behavior by the injunction, but they were still there every Saturday, and often in very large numbers. I'm sure this was happening in DC. I know it was happening in New York as well. So that was my first direct experience with the Women's Law Project. And that's how I met Kitty Colbert. That's how I met the other attorneys at the Women's Law Project at the time, Carrie Nicholas and Rita Bernstein. So then when a position opened at the Women's Law Project, it was in a year or so of that time, I heard about it, I think through Ann Friedman. But I was pregnant now with my second child. And in fact, I remember doing some of the clinic work, in the Operation Rescue case, and, going to the clinics, being, 7 or 8 months pregnant, and the Operation Rescue people, screaming at me. Very odd. So I called them and I was very candid and said, look, I assume you're looking for someone to start immediately. I really am looking, I'm due in June. I'm looking to, take off about 3 months. And they said, well, come and talk to us anyway. So I went and I interviewed. Now, remember, they were familiar with me because of my work in Roe versus Operation Rescue. So that was a very positive thing. And so I walked away thinking, I understand they really need someone now. They're a small office, and, it's just the timing. I was sad about it because I thought the timing's not going to work. But I got a call from Carrie Nicholas. She said, look, we really think you're the right person. So take your 3 months. We can cope until September. So in September of 1989, I started at the Women's Law Project. And I stayed there until 96 or 97, I think 97. So I land at the Law Project in the fall of 1989. That is when the Pennsylvania legislature had proposed amendments to the Pennsylvania Abortion Control Act. And these amendments were the amendments that ultimately were passed and became the subject of the legal challenge in Planned Parenthood v. Casey, which was decided by the Supreme Court in 1992. So I landed at the Law Project at just the right time. My first few months were spent going to the Pennsylvania legislature with various colleagues from the Pennsylvania reproductive justice community, including Sue Fritchie, who was then at the Pennsylvania ACLU. She's now at the Women's Law Project because I ultimately hired her to work at the Women's Law Project, and lots of other great people. And we went into the Pennsylvania legislature and attempted to convince them to just not pass these horrible provisions. That's not a pleasant task. Talking to anti-choice members of the legislature and trying to reason with them, it just doesn't work. You know, they insult you, they just don't get it, they don't want to listen. So needless to say, we accomplished very little in our efforts to get them to either, amend the bill or, just to take out various provisions. So ultimately it passes. And among the provisions are a forced waiting period, a forced 24-hour waiting period, a requirement that women notify their husbands before obtaining their abortions, a parental notification provision that is coupled with the waiting period so that minors have to first notify their parents and then they have to come in to the clinic, and hear the anti-choice lecture and wait 24 hours. So they are essentially combined provisions. A very narrow definition of medical emergency and various other very problematic, burdensome provisions. So we challenged all of these amendments as violative of the standards of Roe versus Wade. It went to trial, and I was part of the trial team. Kitty Colbert at that time had left the Women's Law Project. She was then at the ACLU Reproductive Freedom Project. We had support from a big law firm in Philadelphia, the law firm of Pepper, Hamilton, and Sheets, and a partner named Tom Zamitis. So the trial was largely done by Tom and Kitty, and I was very involved in the trial. I would say they were the leads in the trial piece, and I was more of a second chair in the trial because they were really seasoned. Tom was a partner at Pepper. Kitty had done abortion rights trials before. She had been lead counsel in the Thornburg case, Thornburg versus American College of Obstetricians and Gynecologists, which she had also argued in the Supreme Court, which also came out of Pennsylvania. Pennsylvania just repeatedly passes these draconian abortion laws. We won in the trial court. The judge was Daniel Hewitt, who had been the trial judge in the Thornburg case. It was a very thorough but straightforward opinion. Thorough in the sense were 350 fact findings, and essentially Judge Hewitt applied the standards of Roe, and he struck down the waiting period, the husband notification provision, the parental consent provision, the medical emergency provision, and the record keeping. There are various other provisions that we had challenged. It was a wonderful opinion, very careful. just a straight application of the principles of Roe. The Commonwealth of Pennsylvania, needless to say, was very unhappy with that result. They took it to the United States Court of Appeals for the Third Circuit. We drew a 3-judge panel that heard the case. Kitty did the argument before the oral argument before the Third Circuit. The opinion we got was quite shocking. They refused to apply the Roe standards, and I believe it was the first time that any lower court since 1973 had refused to apply the standards of Roe. And essentially what they did was they basically read the tea leaves, and they said, we believe that when we look at the current composition of the court, we don't believe that a majority of the court would continue to apply the Roe standard.
The Supreme Court, you mean?
Of the Supreme Court, yes. We believe that they would apply an undue burden standard, which they really took from some of Justice O'Connor's opinions. And they applied that undue burden standard. And they upheld, by a vote of 2-1, they then upheld everything except the husband notification provision, which they found unduly burdensome under the O'Connor version of undue burden. One judge dissented. And that judge was Samuel Alito, who was then on the Third Circuit. So when he was nominated for the Supreme Court, we were very familiar with who he was. And he dissented, of course, to stake out a position farther to the right, to say that the husband notification provision was not unduly burdensome. And for that reason, he dissented.
I see. What a guy.
So this was shocking. I mean, you'll probably recall that this made headlines everywhere, right? Court refuses to apply Roe. You know, it sets us up for the Supreme Court. You know, we felt an awesome responsibility. We immediately, of course, met with our clients, who were 5 clinics and 1 physician. And we laid out the options, right, which are, 3 options. Do nothing, kind of live with this. Go back to the Third Circuit sitting en banc and hope we can draw some dissents, because we knew there were some people on the Third Circuit who would dissent. Judge Higginbotham, Leon Higginbotham was then on the Third Circuit. My judge, Dolores Slobodar, was on the Third Circuit still. Or just go right to the court and squarely ask the question, is Roe still the law of the land? I'm not disclosing in confidence to say, because this has been written about before, the clients just unanimously voted to take it right to the Supreme Court. They just thought this was a grievous injustice to women everywhere across the nation, and that we had to sort of call the question. Mm-hmm. So that's, as you know, that's what we did.
Scary. That was scary.
It was scary, but, I felt a little, as a younger lawyer, I was only in my mid-30s at the time, I felt some relief that the clients had decided this, right?
Right. And
they were so clear about it, that this is what was the thing to do. That was a measure of comfort. So we went forward, and at that point, Tom Zamitis left the Pepper firm, and he went to a corporation, and he was no longer able to participate in the case. As a result of that, though the Pepper firm continued to be involved through some younger associates, I then sort of stepped more into Tom's shoes and played with Kitty the role of co-lead counsel at the Supreme Court level. Kitty did the oral argument, but we shared the briefing 100%. And I was there at counsel table, for the Supreme Court argument. And obviously first the cert petition, and then cert was granted, and working on the briefs. And it was a very challenging time, needless to say, for a variety of reasons. Remember, I had a second child who'd been born in September of 1989. This briefing, now she was just a few years old, under 3, I believe. And I had a second child who was just a few years older. And I was going to New York all the time to work on the briefs. We did most of the brief writing at the offices of the ACLU in New York. And we just spent weeks writing the briefs, and we wrote them, we rewrote them, we gave them to people to read, various people that were, within our offices, people who were some law professors that we trusted, legal scholars. We were working on the amicus effort. It was just constant work. It was thrilling, though. I loved it. But it was also just difficult work, because also, as you know, you've had cases in the Supreme Court. There's also tremendous amount of media interest. And so there's that whole piece of it, in addition to the litigation piece. Those two things are going on. And then the public education piece, all of these things are going on. And during this time, Carrie Nicholas, who was the managing attorney, left the Law Project. I became the acting managing attorney of the Law Project.
Wow.
Having only been there for 6 months and having Casey on my plate, it was a wild time. The upshot of when the Supreme Court opinion was issued, we were surprised. We actually were expecting that by a vote of 5 to 4, the Supreme Court would overturn Roe. The timing for overturning Roe would have been good, in that this would have been the spring leading up to the 1992 presidential election. So we were hoping that an overturning of Roe at that time, which everybody thought was inevitable, to the extent there's a good time to do that politically, doing it then, would help elect Bill Clinton. But they didn't do that. What the court did was that they, 3 of them, and we now know from Justice Harry Blackmun's papers that at the 11th hour, let me back up and say that in conference, we now know that 5 votes were cast to overturn Roe, and Chief Justice Rehnquist actually wrote a majority opinion, a draft opinion, overturning Roe. I have a copy of it now. But the Supreme Court process is that anyone, after casting their vote, can change their mind, up until the point the opinion is released. So sometime in May, Justice Kennedy writes a note to Harry Blackmun, and that note is in Harry Blackmun's file. It's not an email message, it's a handwritten note. And it says to Harry Blackmun, Harry, I'd like to see you. Some of what I have to say to you will come as welcome news. And apparently they go out into the garden of the Supreme Court, and Kennedy tells him that he's decided to change his vote, to uphold, everything except, to uphold everything except the husband notification provision, but to not overturn the core of Roe, and instead to substitute this undue burden standard, which actually is a little bit different than a little bit more forgiving than the original O'Connor undue burden standard. So that's actually how it went down. So Kennedy joins forces with O'Connor and Souter, and then of course Stevens and Blackmun are there. They would have retained Roe in its entirety. So it's a mixed, in the end, it's a mixed bag, right? So that the essence of Roe is retained, but we get this so that we you know, bans on abortion are not permissible. But, and undue burdens are not permissible. But this new undue burden standard is a very, I believe, very problematic standard. You know, it's a very subjective standard. It's a standard that can be manipulated by judges and justices who are not supportive of the right, to basically allow the states, you know, to pass lots of restrictions. So it's a standard, I think, actually, as written, and Kitty and I wrote an article about this in the Yale Law Journal, that I think if you read the opinion closely, there are things about the standard that are very positive, and if it's correctly applied and applied so that it has some teeth, it could be a decent standard. It's not the Roe standard, and I would much prefer the Roe standard.
Of course.
But I think, sadly, you know, the standard has largely, you know, has been applied in very problematic ways, and that will continue now with the current court, if they ultimately retain that standard. And it looks like, you know, after the June Women's Medical Center this term, we'll have the undue burden standard, you know, for a while, I suspect, since it's been essentially reaffirmed now.
May I ask you on that? People have said to me that this June medical case is kind of does to Casey what Casey did to Roe. Do you have a comment on that?
I think the Roberts opinion, yes. I haven't read it I'm sorry to say that I've read it quickly, but I want to go back and read it with my yellow marker. Roberts, you know, he writes a separate concurring opinion, and he cast his vote, you know, to adhere to whole women, you know, to the outcome in Whole Women's Health, which was, you know, to strike down these laws in both states in both cases. He writes separately, I think, to ensure that the undue burden standard, yes, is going to be applied in a more watered down way. He's not accepting a sort of balancing test where you look, you know, if the law doesn't have any benefits, that helps you show that it's unduly burdensome, right? He rejects that whole balancing analysis, as I understand it in my quick reading. And he says you have to show a substantial obstacle. And if you can't show that, you know, and that's difficult to show and expensive in terms of litigation and just really tedious. So yeah, I think he does damage. And he knew that's what he was doing that intentionally. When I was at the Women's Law Project, I taught the sex discrimination law course at Penn Law School. I taught a sex discrimination law course, reproductive justice course in the Penn undergraduate school. And I really loved, I came to really love teaching. So I left and I went to Rutgers Law School, and I was teaching some courses. I taught family law. I taught a course in abortion rights, and I was running a little clinical program that was in my other the area that I also am really passionate about, and that's Title IX. And so it was a sports and gender equity legal clinic that I was trying to get off the ground with at Rutgers Law School. But I was on soft money and trying to get them to support it with money. And I did that for a couple of years. And then ultimately, I got an opportunity to come here to Stockton University, which is one of New Jersey's state institutions. And I teach in the political science program. And when I came here, it was a 3-year visiting position for someone who would teach constitutional law. They had this tradition of having someone who was actually had been a practicing lawyer, who would come to Stockton and teach, from their practical experience. So Frank Corrado, who's a pretty well known in New Jersey First Amendment free speech lawyer, had the position before me. He had been chair of the ACLU board in New Jersey, and he was a friend from law school. And he finished his 3-year stint, and he called me and he said, "I've really loved being here at Stockton. It's a great place, great colleagues. Would you consider doing this for 3 years?" And I said, Frank, I'm at the law school, and I hadn't really thought about undergraduate teaching other than the one course I do at Penn. He said, "Come here and meet the folks. I think you'll like them." And I did, and he was right. They hired me. I was here for 3 years, 2004 to 2007. And then the new president said, "I don't really like this 3-year line. I want it to be a 10-year line." They wanted me to stay. I then got tenure. I then became a full professor. So now it's 2020 and I'm still here. And I've done all of my writing, though, in law journals. And I also am the pre-law advisor. So I love being here. I love the opportunity to teach young people, and I do teach a women in the law course. I teach civil liberties and civil rights, and I build a big sex discrimination component into that. Most of my writing has either been in the area of reproductive rights, or I have a law journal article that I think you referred to earlier that's about state equal rights amendments, because having been at the Law Project, the Women's Law Project, and seen how effective a state ERA can be. So that article actually has been cited quite often, mainly just because no one had looked at state ERAs in 20 years or more. And now that the ERA is so hot, people are again sort of curious about state ERAs as well. So now I've become somewhat involved in the movement to finally get the federal ERA passed. I've been involved in that for a while, but more recently in the ERA coalition and the legal task force that they've formed. So that's been a pleasure, and it sort of kind of brings everything full circle.